All right, a lot has happened in the crypto market over the past 24 hours. First of all, a lot of you guys have noted that apparently some crypto assets are securities, complicating Coinbase and Ripple cases. This was just posted on CNBC, and it reads, "Crypto are considered securities regardless of the context in which they are sold," a federal judge said. The opinion came from the same Manhattan federal court that handed down a controversial ruling in the Ripple case that said the opposite. Private companies, lawmakers, and regulators have tussled over whether crypto are considered securities, and I think a lot of other YouTubers might have already dived into this situation. But with cases like this, I always like to wait a little bit extra because they're not that influential for the price anyway, and see whether or not they really impact stuff, see whether or not there are clarifications and what the lawyers say and whether or not it's really true. And even though Coinbase stock did not really react well to all of this, Ripple really wasn't harmed too much. XRP really wasn't harmed too much. I'd say that only Bitcoin fell down below 29, which caused Ethereum and XRP to fall ever so slightly. But you can see we're basically in this zero type of status that we've been in for a ridiculous amount of time by now. So, a Manhattan federal judge said in an opinion that crypto are considered securities regardless of how they are sold. And indeed, this does make things a little bit more difficult because even though he's wrong, it's going to be a little bit annoying if different judges start saying different things, right? It doesn't matter to XRP, guys. Do not fret. Do not worry. XRP is not a security regardless of what this other judge says. Then again, it allows the SEC to pursue securities charges against Terraform Labs and its founder, Do Kwon, and has broad ramifications for crypto legislation and litigation. At least it makes it more difficult. Like it says right here, it'll not impact the prior opinion, from whatever happened in the Ripple case. The Ripple ruling was considered a win by the industry because it said crypto may or may not be a security depending on who's buying it. The SEC had argued in cases against Binance, Coinbase, and Kraken that many crypto listed on these exchanges are securities, like they're also doing now against Mr. Richard Hart from Hex. If you didn't see my video yesterday, it was pretty crazy of a situation. The court declines to draw a distinction between these coins based on their manner of sale, such that coins sold directly to institutional investors are considered securities, and those sold through secondary market transactions to retail investors are not, Rakoff said of the prior ruling in the Ripple case. In doing so, the court rejects the approach recently adopted by the Ripple judge. Kwon and Terraform Labs are accused of committing a massive fraud upon investors through an unregistered offer and sale of multiple crypto assets, including Luna and a stablecoin called Terra USD. The opinion from Rakoff also lends support to arguments from lawmakers who have said that crypto legislation is needed to clarify the role of regulators and the courts over crypto markets. The SEC has pursued numerous other crypto firms over the alleged unregistered offering and sale of securities, including Coinbase, Gemini, and Genesis. And over on Twitter, you can see the amount of people that are just overzealous about the situation. And that's why I waited, because it was such a hyped up decision. But more importantly, obviously, with the SEC was whatever they filed against Hex. So I've been focused on that for a little bit. A federal judge denied stablecoin issuer Terraform Labs' motion to dismiss a lawsuit on Monday. The judge slams Ripple's decision in the SEC case against Terraform Labs. You can see some of the guys coming in hot saying, the judge's opinion in Terra is far from a complete departure from the Ripple holding, contrary to some commentary that's already circulating. He agrees with the fundamental premise in Judge Torres's decision that tokens themselves are not investment contracts. What matters is how they're sold. Here's the key language. Quote, to be sure, the original UST and Luna coins, as originally created and when considered in isolation, might not then have been by themselves investment contracts, much as the Orange Groves and Howie. Would not be considered securities if they were sold apart from the cultivatory's premise to share any profits derived from their cultivation. The term security also cannot be used to describe any crypto asset that were not somehow intermingled with one of the investment protocols did not confer a right to purchase another security, or were not otherwise tied to the growth of the Terraform blockchain ecosystem. But the application of the Howey test, particularly the reasonable expectation of profits prong, yields a different result in the Terra than Ripple case. In the court's view, all investors, not just primary or institutional purchasers, were led to believe that defendants could profit by unloading UST into Anchor, and that profits from the continued sale of Luna would be fed back into further developments of the Terra ecosystem. The defendants said that sales from purchases of all crypto assets, no matter where where the coins were purchased would be fed back into the Terraform blockchain and would generate additional profits for all crypto asset holders. Simply put, secondary market purchasers, and by the way, if you've not done it yet, make sure you go ahead and press that like button on this video. I'm trying my best to get you guys the best crypto news out there. Simply put, secondary market purchasers had every bit as good a reason to believe that the defendants would take their capital contribution and use it to generate profits on their behalf. The key point is, this Judge Torres arguably could have reached the same result in Ripple without being unfaithful to the logic outlined in her opinion. She just didn't have the facts available to do so. And now, of course, there are some naysayers everywhere. This guy, I believe, was very much against the Ripple situation, the Ripple case. And there are, in the end of the day, many differences here between Terra and Ripple. I still believe both of these, and specifically here, whatever the judge said and whatever they're thinking, is going to be irrelevant for the legislation side of things, as they will, of course, take into consideration all that's happening in the background. However, some others are putting it way further. XRP ruling rejected. Secondary market sales are also securities. Bitcoin independence, yada, yada. Now, John says, this is what you call freaking gaslighting or clueless on how to read a legal decision. The judge's ruling never said secondary market sales are not securities. She only said what you must do. You must apply the Howey factors to each transaction of the asset when deciding whether there's an investment contract, transaction, or scheme. The correct answer, under the law, is a token sold in the secondary market off an exchange. Could be an investment contract. You don't know until you apply the Howey factors to the circumstances surrounding the sale. The judge used a second sale of the Howey orange groves as an example. If the second purchaser bought not from Howey, but from the first buyer, and was completely unaware of the Howey company, and all that was communicated during the second sale was, do you want to buy my acre of orange groves? And the second buyer said yes, and was planning on growing and selling the oranges himself. It is clearly not an investment contract. Point being here, a lot of context matters. On the other hand, if the first buyer tells the secondary buyer, buy this orange grove, and the Howey company will do all the work for you, all you do is sit back and collect profits from doing nothing, you might have an investment contract. That's not even controversial. I've never seen this much FUD over a simple legal ruling in my life. So again, there's a lot of criticism, again, surrounding XRP and the judge and whatnot. A lot of it is misguided. Stewart said, let me be clear about some confusion going around. The ruling in the Terra case changes nothing about Ripple and XRP. Also, the Terra case is just starting, and that judge has to accept everything that the SEC alleges as true for now. Our ruling came after a full factual record developed over 2+ years was presented to the court. This is, again, coming in from Ripple. I'll let others dive into the Terra judge's comment, including his apparent misreading of the Ripple's judge's reasoning. Example, missing the point that secondary market traders can't invest money in anyone or anything if they don't know who they're buying from. Yeah, and again, if you're wondering, the simple answer is, it doesn't change anything for XRP, it doesn't change anything for Ripple. This judge is saying something, who cares about what they say? It matters what the result is from all this. The case is just starting, so I'd say let us see over the next couple of months whatever comes out. I'd say as of this point, it's just a matter of, hey, this judge is pretty clueless and is just putting out facts on the table. Again, assuming a lot of what the SEC says is true and applying Howey at a really basic way. Eventually, though, they might completely change their mind, depending, I'd say, on how other things are going in the crypto lawsuit landscape. Like I've been saying for a while, guys, and I've said this, I've warned you about this a little while ago, the SEC's attack on crypto is going to strengthen from here. The fact they went after Hex shows me many different assets are about to come, and at the end of the day, the only one that is officially safe is XRP, and the second one that's almost safe is Bitcoin. The rest is not inherently safe, which is maybe potentially why the market isn't going in a full-on frenzy just quite yet, a full-on bull run like crazy, because there's such a massive amount of fear. That does not mean, however, that XRP can be touched with whatever any judge says. It cannot be touched for right now. The only way things can change is if the SEC goes to appeal, which again will probably take another couple of years. And even then, they'll probably not win. So XRP, in my opinion, and most legal opinions I've read, is safe for forever, or at least the next couple of years. Again, I'm not a legal advisor, not your financial advisor. I've just been interpreting everything what's been said on the interwebs, and honestly, it makes a lot of sense. I mean, at the end of the day, a lot of about these securities laws, a lot about these securities facts is up to interpretation. And do you guys remember this video?
Look at you.
No, I want to be clear. I do not respect the SEC. I do not respect them.
But you're abiding by the settlement, aren't you?
Because I respect the justice system.
At the end of the day, it's not about what the SEC alleges. It's about what the judges officially rule in the end. All this intermediary stuff we've seen with the Ripple case too. The judge might make wrong assumptions. The judge might make wrong distinctions at the start between, oh, no, that was this type of offering, that type of offering. Or perhaps, hey, the whole Luna case is just a lot different than the Ripple one, and it turns out Luna messed up. You know, the guys at Terraform Labs messed up. It could be. I'm also not out there shouting that no cryptocurrencies ever can be sold as securities, because they can, depending on how things go. I am saying, however, that I do not believe that any single crypto asset is a security of itself. That, again, does not imply they cannot be sold as one, because, again, a security, an investment contract, you can sell something as an investment contract, but that does not mean the asset that you're selling is the investment contract. That's where the distinction lies. And this judge, well, they're just getting started. Like I said, let's wait for it all to come through. Again, years of research are going to be necessary, and it's probably going to take another years of research to get to some conclusion. Over time, probably we'll get some more crypto rules going in anyway, and probably by then, hopefully, Gary Gensler is fired, and some new normal people have come into the SEC. They're not as money, power, or whatever hungry. And at that point, they might take a step back to say, hey, you know what? Let's not try to destroy the US. Let's not try to destroy crypto. Let's play the fair game. Then again, perhaps these guys are being manipulated also to go into this side of things with all their negativity. I don't know. But yeah, there are going to be many different cases that will probably pop up over the next couple of weeks. And I'm going to be informing you over every single thing about it, which is why I keep saying, guys, if you've not done it yet, make sure you put that notification bell on. It is critical. It's imperative you guys do that. And I'll see you guys again in another crypto video, hopefully later today.